I'm going to start with my disclaimer here, which addresses kind of the question that Christian asked. So my job, I have a master's degree in library science, and I do have a law degree. But one of the benefits of what I do is, well, it's not necessarily benefit, but I don't practice. So my primary job is to provide information and authoritative sources and enough to permit libraries to kind of make their own decisions on what they want to do, having the accurate information. And perhaps have enough information based on what's going on or based on the law involved that you could take it to your attorney and perhaps save some money or have a greater understanding of what's going on when you discuss things with your attorney, which can also save some money. So today we're going to be looking at these employment issues with like an eye towards information to give you a better understanding of what some of these issues are and the some of the things you should watch out for, as well as some of the possible solutions you could consider. So when we talk about employment law in general, we're usually talking about a range of things. So in this list are some of those things that generally are covered under when we talk legally about employment law. So everything from recruiting, hiring, onboarding, job descriptions, policies, procedures, firing, evaluating, coming up with benefits and compensation, things like wages and hours. Generally, when you use the word employment law, that's different from labor law, which generally deals specifically with unions. And that's kind of another area of law. They do intersect, but mostly what we're going to discuss today is not going to be in the realm of labor law. So what we're going to be talking about today is a lot of what we're going to be talking about today is going to have to do with policies. Policies form the fundamental backbone of a lot of libraries and a lot of other businesses' activities. So a lot of times when there's conflict in the workplace or there's issues in the workplace, it all centers around a policy. Or when you're drafting policies, the reason you're drafting policies is to comply with a law or to ensure your employees comply with a law. So, those policies become very, very important in how well your workplace functions and how well or how easy it is for the employer to address any particular issues that might come up. So when we talk about policies, generally, policies are there to protect the library, protect the board, and protect the staff, right? Because it's, as I said, it's the mechanism to help you comply with the law. It's the mechanism to make sure that employees are notified of what's expected of them and what the rules are. And it also is the rules for the employer too, which would be the board and the director, right? So when you're drafting policies, you want to make sure that you offer due process as a part of every policy. And that means that when you're drafting policies, you want to ensure that the policy provides notice so that there's notice of the policy, that there's notice of what the policy contains. That can be as easy as posting the policy or providing the policy in an employment package that you hand the employee. There can be an online, version of your employment handbook that employees all have access to. And that also applies to we're talking about employment, but these same rules apply to like patron policies. You want to make sure that part of your process for addressing alleged violations of policy, is investigation, right? That if someone reports someone else, you don't just take their report on face value. As an employer, you're going to do a due diligence and, see what happened, get the story. What did happen? What were the circumstances surrounding this alleged violation? Was it really violated? And lastly, you're going to make sure that there's an appeals process so that if an employee feels that they were unfairly targeted or they feel that the policy is being misapplied or they feel that the policy is unfair or illegal, they have a place to go to tell their side of the story and advocate for themselves. Most of the time in a public library, the appeals process would be the board, because remember, it is the library director's job to handle the staff. So the library director would kind of be the first, the first level of the court process, so to speak, of the adjudication process for policies. If you have a very large library, the director may be an appeals process. So if you have a lot of layers of supervisors, maybe the supervisor is the first, judge of the policy and issues the first determination. And then after that, the employee can go to the director, and then after that could go to the board. A lot of this just depends on the size of your library and how you work. You want to make sure your policies are legal, right? You want to make sure that they're enforceable, that they're clearly written, that they comply with all applicable laws. Just because you want a policy in your library doesn't necessarily mean you can have it, right? You can't just make your employees do just anything that you want or hold them to any kind of standard. There has to be some kind of basis for that. So the best way to do that is to make sure that your library attorney, preferably an employment attorney, reviews those policies. If it's an employment policy, if it's a standard policy like a patron policy, you want to make sure that your library law attorney reviews it and make sure that everything is appropriate within that policy. And that's a good thing, because a lot of times the attorney may ask you questions and spur things that maybe you didn't consider. And this is also true that sometimes it's a good thing to vet policies when you draft them. Whether you draft them with an attorney or whether you draft them on your own and then show them to an attorney. Maybe have someone else involved. So if you have a policy that is, especially if it's a potentially controversial one that is going to affect staff, maybe have a staff representative take a look at it, or maybe have a supervisor in that area take a look at it before putting it in stone. Because again, sometimes depending again on your hierarchy and how far away the person who's drafting the policy is from the reality of the people who are going to have to actually live under those policies, there can be some differences there. And sometimes having the people involved who are going to actually have to either enforce the policies, or if you're talking about a patron policy, or someone who's actually going to have to follow the policy, it might not hurt to get an opinion. Doesn't mean that you're not letting them drive the bus. It just means that you're getting valuable input about ensuring that you can have an enforceable, workable policy that also communicates exactly what it is you need it to communicate, or to do exactly what you need it to do. Make sure that everybody's trained on the policies. You can have the best policies in the world, but if you just hand them out to every employee, and say, okay, you have to read this. You can even make the employee sign a paper that says they have read it, but that doesn't necessarily mean they've read it, right? That may protect the employer from an enforcement standpoint, but we all know that this is not just about, enforcement. It's not all just about the employer getting their way, because the enforcement process can be a lot more stressful and a lot more difficult than just ensuring that everybody does what they're supposed to do, right? So training can ensure that the staff actually read the policy and actually know what the policy is and actually understand what their responsibilities are under the policy and what the expectations are of the employer. And once everybody's on the same page about that, whether the employee likes it or not, then you're starting from the same point. And after that, the enforcement of the policy and discussions about issues with the policy go a little bit more smoothly. Not always, but the odds are they will go a little bit more smoothly. And the odds are there may be less conflict and less violation of a particular policy. You want to make sure that the policies are clearly worded so that when the employee does read it and is trained on it, it is very clear as to what the policy A is intended to do, and B, what the expectations of the policy are, and what constitutes violation of the policy, right? So that there's no squishiness about, policies should not be worded so that they're subjective. They should be worded so that they're very clear. This is what you must do. This is what it looks like when you're not doing what you're supposed to be doing. You want to make sure that when you implement new policies, and particularly when you implement changes to existing policies and changes to long-standing existing policies, and we're going to be talking about that a little bit later, but this again can be particularly important if you're changing popular policies. You want to make sure that that implementation is organized and transparent, that employees understand why the policy is being changed, right? Technically, as employers, do you have to tell your employees why you're changing a policy? No, right? But is it a good practice too, especially if you're changing a policy that might be very popular, or that the effect of changing the policy is something negative on the employee, like you're reducing maybe a leave policy, or you're making something a little bit more strict. So it's, employees are going to feel that they're losing something they had. If that's the situation, it's in the employer's best interest to have a frank conversation with employees and notify them, look, we're changing this and this is why. You don't necessarily have to go into huge amounts of detail. It could be as simple as, the budget is very tight, and, or, we're short staffed, or, there could be, simple reasons, but you want to make sure that you provide reasonable explanation and hopefully truthful explanations, because that can make a bitter pill go down a little bit easier with the employees. You want to make sure all policies are equally enforced. You would be surprised that, it's everybody thinks, of course, they have to be equally enforced. Of course, I'm going to equally enforce them. But then you get that employee who is much beloved and has been there forever, or could be new, but an employee that everybody loves, that does a really good job, but has one quirk, right? And has a quirk that, that quirk results in violation of policy. And maybe initially that's not such a problem, but then maybe it goes on, and maybe now it's affecting another employee. You have to be very careful about enforcing policies only in some situations and not others, right? Because, oh, that's Betty, and everybody loves Betty, and that's just how Betty is. Betty is a straight talker, and she just says what comes off her mouth. And then on the other side, you have Ben, and Ben is has an unfortunate conversation, and it's, oh, he's insubordinate, or he insulted a patron, or you have to be very, very careful about that. So you want to make sure that regardless of how engaging an employee is, that all of the policies are enforced in a similar manner. Equally, everybody is under the same restrictions or requirements. And you want to make sure that everybody supports each other. So again, with a larger hierarchy, make sure that the people above support the people below who have to enforce policies, and the people below should support the people above who may have to implement policies. So there may be a policy that comes into effect that a supervisor is not happy with, but understands. And then when it gets to the employees, the supervisor is like, oh, I know this policy sucks, or this policy is horrible, but we all have to follow it, and I know it's dumb, and I don't want to have to do it. That is that supervisor kind of sabotaging those above her. On the other hand, if a supervisor is trying to enforce a policy and people above them are like, well, that's not such a big deal, and we really like this person, or sometimes it's, oh, their families donate a lot of money, or their family is really important in this community, can't we just let this kind of slide? That is not supporting the supervisor. So it's very important that all the hierarchy is on an equal footing, and an equal the same page with regard to how things get enforced. Okay. So let's kind of delve into our scenarios. And I know I really debated about how to do this, and I am not, half of my family are graphic designers. Unfortunately, I did not get that gene. So I went back and forth, but I kind of figured from the standpoint of providing access to the slides, maybe it was better to explain the scenarios rather than just show pictures. So this kind of presenting is a work in progress, so I apologize if just all the words seem boring, but I'm going to go ahead and relay them so you don't have to just read it all. So our first scenario has to deal with the Everytown Public Library, which is what we're going to use for all of our scenarios today. The Everytown Public Library is analogous to probably like a class 3 or 4 in Michigan. It is, at Everytown Public Library, we have Sally, and Sally is a library clerk, right? So she is a library clerk frontline worker. She's worked at the library for about, 5 years. So she's been there a little bit of a time. She hasn't been there forever, but she's been there enough to kind of be entrenched and to understand what's going on and to be familiar with everything. She's generally a good employee. She may not be a perfect employee, but she's generally a good employee, has pretty good evaluations. She generally follows policy and is pretty well liked by all the patrons. However, she has an unfortunate habit. So Sally is very social and she likes to chat with her patrons when she's helping them check out. And she, a lot of times she has regular patrons and they kind of befriend each other. And Sally has a very soft heart. And sometimes it happens that when a patron comes in and needs a little bit of a favor because they've maybe they want to check too many books out, or maybe they want a computer for a little bit longer than they should have it. They can go to, they go to Sally and, they can cajole her, and Sally will bend some of the rules for these patrons. Now, the problem is, as customer service would dictate that, again, like the Disney model of customer service, you want to empower your front line to make, within reason, to satisfy the customer, and maybe to make little allowances where it makes sense and where it is necessary. But this scenario is that Sally kind of provides, she bends rules for some patrons but not others, right? And the factor that determines whether or not the rule is bent tends to be whether or not she's friendly with the patron. So if a patron talks her up and becomes friendly with her, she has a tendency to bend these rules. If she doesn't know the patron, she's not rude or anything, but she just does what she's supposed to do and she adheres to procedure. So this has come up where people have complained and said, they're behind someone in line and that person gets a kind of a benefit of doubt or a bending, and this next patron wants it and doesn't get it. So occasionally there's been complaints against Sally for this kind of behavior. And she's been reminded a few times that this is not appropriate and you can't enforce policies subjectively, right? If there's a real issue and you have a patron that is experiencing an honest, problem, or you have a scenario where it really makes sense to bend the rule once in a while, that's okay for customer service, but it shouldn't be a regular thing. Well, then we had a situation where one of her patrons that she is friendly with came in, and they're a parent. He is a parent of a child, and he, wanted to access some information on his kid's record. And, Sally was like, well, I'm not sure. Let me see. So she looks and she notices that the parent is not on the record that the child is on. In Michigan, the parents have ownership over their kids' their kids' records under the Library Privacy Act, the ownership of the record goes to the person who is responsible for paying the fees or fines or replacement on the items, checked out. And in this particular record, it was not the father standing in front of Sally, but the mother who was on the record. And Sally thought, well, it's the parents, so I'm going to go ahead and give him the information. I mean, they're both parents. So she did. So the next thing, it turns out that when the director came back from lunch, there was a parent waiting for her. And the woman was extremely irate and upset because information had been divulged about the child and what the child was reading to the child's father, who is the non-custodial parent in a very highly contested custody battle and divorce. Now, the record didn't reflect this. There was no way Sally could know this without, asking her. But, the fact is she divulged information to a person who was not on the record as having permission. And that includes, sometimes in notes, libraries have the option for, say, members of a family to give each other permission to access records. And this was not the case here. And in fact, there was a note in the record where the custodial parent had specifically said, please do not give information to the non-custodial parent, to my husband. So, and Sally did not see that note. So this, parent was very irate, and she was demanding that Sally be suspended or fired. And her parting words to the director were, and I'm going to see if I can sue. I think I may sue for this. Well, the changes to the Library Privacy Act in the last, recent, I think it's in the last year, the years all blend together, but recently changed things a little bit for the Library Privacy Act and has made it very clear that not only is the library, could be fiscally liable for damages if information is knowingly disclosed, but so could the individual employee. So this could potentially be a big deal because, not only did Sally divulge the information, but she arguably divulged it knowingly because she's been trained on the Library Privacy Act and the policies and how they work at the library. So she should have known what to check for before giving the information, what questions to ask, and when not to provide information. So the director, who really likes Sally, very much values Sally's work, but she is very frustrated by this turn of events because it's one more example of Sally not following procedure, and especially after she was recently specifically asked to please make sure that she, levies these policies equitably and similarly across the board. The director just doesn't know what to do. She's not sure what to do. The board is concerned about the liability and wants to fire Sally for this because Sally violated the law. So what are the issues here? So the issues here are A, the Library Privacy Act, and at-will employment, right? Because the board wants to know, can we just fire Sally without having to worry about going through all of the steps in the employee handbook or all the disciplinary steps? Can she just summarily be fired? So when we look at the Library Privacy Act, which is not specifically an employment law, but has a lot of impact in libraries and how we operate, some of the questions you want to ask about the Library Privacy Act is, was Sally trained in the requirements of the Act? Because that could go to knowingly, right? Because the law says, was she, did she knowingly divulge that information? If you divulge the information by mistake or inadvertently, it's still a problem, but it's not, doesn't rise to the level of, personally liable. So, but the library could still be liable even if it was done by mistake. So the question is, was Sally trained in the requirements of the Act? Does the library have a written policy and procedure for staff for the Privacy Act? So again, this all goes to some of the library's liability. In other words, did the library do everything they could do to ensure that the information would be safe and that the Privacy Act would be upheld? And so, these are some questions to ask yourself. And again, is one of these things is making sure that you have a good legal policy in place on, how the library handles the privacy issues and what staff should be doing. For those of you that aren't sure, the Library Privacy Act is an act that essentially makes information that is in a patron, it's called a library record, right? And a library record includes all of patrons' personal information, their reading histories, and essentially any kind of instance, so image, information, where a person, a library patron or person using the library can be personally associated with services of the library. So whether, you can identify, Joe, who is, on the computer at the library at this time, researching this, or Shirley is at the reference desk at this time and she asked this question, or Billy checked out these books and is researching this topic or reading this series of books. So all of these things would be counted under the Library Privacy Act. So it's very important now, even, there's always been liability attached to the violation of this act, but recent amendments have made it very clear under what circumstances and who is liable. So in this instance, the library would be liable and the employee individually could be liable. So this is very much within the library's interest to, have a solution to what happened here. So under at-will employment, the at-will employment is a phrase that you may have heard of. I'm sure you probably have heard of, and sometimes it can be confusing to know exactly what that is. So at-will employment is a doctrine that says that employers, and it's prevalent throughout the United States, and it generally says that employers can hire, employers can fire employees for anything. So usually when you talk about termination of an employee, it's like at will or it's for cause. And for cause means that an employee can only be fired for a legitimate reason, violation of company policy, insubordination, violence, breaking a law. A lot of times, employers will have an employee handbook or policies that specifically state things that can put an employee in danger of termination. So that's for at cause. At will says there doesn't have to be a reason. I can just decide, we don't need this person today and you're gone. So there doesn't have to be any real reason to fire the person. So Michigan operates under at will. So at will is the default in Michigan. But there are some circumstances that can change at will for a company, even if the company doesn't intentionally say, we're not going to be an at will company. And some of those things are, if you have an employee handbook, and that employee handbook is structured in such a way that the procedures tell the employee essentially that they are safe from termination unless they violate these things, or unless they're in this circumstance, like at cause, in a just cause, they violate a procedure or a policy, or they're insubordinate. Or so if an employee handbook gives the employee the assurance that, oh, you're pretty safe here unless, this and this, unless you, commit these offenses or you do these things. And sometimes that can be expressed just within the discipline process, right? So first we're going to warn you, then we're going to write you up. And then if you get this many write-ups, you're in danger of termination. So, sometimes that kind of wording could affect a company's at-will status. The exception to this would be if the employer clearly has statements within the employee handbook that say we're an at-will employer and employment here is at will. And some employers even have new employees sign a statement that says, I understand this is an at-will employer. All of those things affirm the at-will employment status, whereas, not doing that and having just, a very detailed policy of how you're going to handle employees who are, having problems can affect your at-will status. So this is something that you really want to address with your attorney. If at-will status is something that is important to your library, you want to make sure that you discuss this with your employment attorney, hopefully before you have a problem, so that you can ensure and protect yourself and protect your at-will status. And so that's, and again, I'm going to say throughout this presentation that having access to an employment lawyer is crucial. Libraries have a lot of really unusual issues. And because libraries are public employers, so public employers are a little different than private employers, right? So GM and stores and other corporations are private employers, right? Even if you're a publicly held company, it's a private employer. But governments and government entities are public employers. And so sometimes different things apply to public employers than they do private employers. So that, in addition to a lot of the nuances of a lot of these employment situations, mean that it's very important for the protection of the employer as well as the employee that you have a contact to a good employment attorney. And if you are looking for one, let me know and I can, kind of send you in a direction of how to find one. But it is crucial that you have one, and it's very much worth the cost to have a good attorney. And hopefully you already have a library attorney, and you can also talk to them and ask them, look, do you know a good employment attorney? And chances are they do. So that's also a really good way to locate one. So those are things you have to consider, right? If you've ascertained, that you are at will, then the choice is on the table to just fire Sally. You want to make sure too, if Sally has an employment contract, because that's another thing that can affect at will. If you have, an employment contract that specifically sets out, circumstances under which you can be terminated. If the employee is at will, some of the things to consider are, did you follow your own process? So if you have a situation where you say your employee is at will, but we also have an employment manual, did you follow your own processes? Did you document, right? So did you document information that you had with Sally? This is also true if you are not at will, and if your attorney comes back and says, well, I'm not so sure that you can fire at will. You may have to do it in a just cause or in a cause for cause manner. And that's when things like whether you followed your processes, whether you've documented, become extremely important. In order to, fire and not risk a wrongful termination lawsuit. Now, one of the things that are on your side here as an employer is that Sally did violate the law. At least it looks like she violated the law. So if you and your attorney ascertain that, okay, yeah, we're pretty sure this is definitely, there's a very good argument here for knowingly violated, then odds are that you'd be able to go to Sally and, convince her to resign or, kind of offer her kind of an alternative rather than a flat out at will, firing. Now, the one thing to know about at will is that, at will is not necessarily a guarantee, right? As we spoke, there are some things that can affect at will. So that's very important. And again, it's very important to talk to your attorney about the correct process of firing at will. oh, and we mentioned if she was trained in the Privacy Act, then that could affect things. You want to make sure that if you have an employee handbook, that it is, and if you have never had an attorney look at it, have an attorney look at it, not only for the at-will question, but also to make sure that your individual employment policies are legal and appropriate. Okay, so, you know, in the end with Sally, depending on whether there definitely is enough, you know, what she did was definitely a fireable offense, right? How she is fired kind of, you know, is determined by whether the library is at will or whether it would have to be for cause. The other thing to consider is whether you don't want to fire Sally. You know, maybe you really value Sally and you know, this is just a terrible mistake and she understands and you know, you don't want to fire her. That's also under the employer's prerogative. But one thing, you know, again, to discuss with your attorney in this particular instance is, you know, the fact that, you know, now we have a law in play that was violated, and how will retaining Sally versus firing Sally affect the library's liability or negative impact from this situation. So the second scenario. So here we have Alfred. And Alfred is also at Everytown Public Library. He is a new employee. Now, Alfred is an older gentleman who was an engineer, and he is now retired. And he has decided, you know, he kind of came to the library because he thought, you know, I'm newly retired. I'd like to make a little extra money. I'm bored at home. I would like to keep some of my skills up. And, you know, I think it would be fun to be in a library all day. So he applied for and received the job that was available to be a facilities worker for the library. Now, his job is to, you know, monitor the building, you know, tweak the HVAC, do minor repairs to plumbing, electrical, and the HVAC system. He is certified in all of those things because of his long career as an engineer. He also is there to help staff lift some heavy things, to help shift large quantities of books when that's necessary, move stacks, and also help the Friends group with their book sale in terms of moving tables and helping them get their boxes of books that they store in a back room at the library. As the donations come in, they store them in boxes, and then, you know, when it comes time for their book sale, they bring them out. So his job would be to help them get their books out and bring them to the room where they have their book sale. So, you know, in the interview process, you know, when he was told what the job was, and he was asked, you know, whether that sounded okay to him and whether he, you know, all of this physical activity would be a problem, which is a question that they would ask everybody. He maintained that he'd have no problem. You know, that was listed as a qualification in the job description. And he said he'd have no problem meeting that qualification of lifting 50 to 60 pounds or lifting and handling folding tables. Now, unfortunately, also, Alfred actually miscalculated this. So the first time Alfred had to lift and cart boxes, and the first time he had to help set up for the book sale, it was a pretty bad experience for him. And it severely exacerbated some existing conditions he had in his back with and his arthritis. So he has some arthritis in his knees, he has some arthritis in his back, and a degenerative disc condition, most of which does not affect him in his day-to-day life, but he is finding that this constant lifting and constant carrying of heavy things is starting to take a toll. He also just doesn't like it, but, you know, that's beside the point. So he came to the library director and he said that he would like an accommodation. He would like an ADA accommodation for the lifting and carrying parts of his job. And, you know, he is a part-time employee, but he does meet the qualifications for being covered by the ADA. The public library is also covered and must adhere to the Americans with Disabilities Act. And so he is requesting either a flatbed cart that has either a mechanical or a pneumatic feature that would raise the bed of the flatbed up to the height of a table, so that he can take the cart, or higher, so that he can take the cart to the storage room, slide the heavy box onto the bed, lower the bed, bring the cart to the room, and then raise the bed to slide the box of books onto the table, so that it wouldn't require him to lift or to carry. His other option, which he actually says he prefers, would be to hire an assistant who could do those duties for him, in addition to some other things maybe that could help him out. So the director, investigates this and, or finds that these carts can cost between $500 and $1,000 for a decent one, depending on features and how high they go. And then an assistant would have to be paid the library base rate of $12 an hour for part-timers. Plus, the library does offer some part-time benefits, so those would also have to be included. The library's budget is set for personnel, and the director has no padding in that budget. So hiring a part-time person with a fair amount of hours might require a budget amendment, and that's something that the director is a little bit concerned about. So the director is trying to determine how to handle this, and she's very sympathetic to Alfred. She likes Alfred. He's been doing a good job. But she's a little bit upset that this, that he didn't volunteer this potential and this condition when they hired him, because they did emphasize that he was going to have to do a lot of climbing, a lot of carrying, a lot of lifting. She's a little concerned because some of these accommodations are a little expensive and they may not be on the budget. She may have to scramble to find funds. She actually would prefer a different compromise that might permit her to either ask the Friends group to hire somebody to specifically help them with their book sale. And then the cost would be borne by them, and she could just change some of Alfred's duties. Or she could enlist the assistance of other existing library staff to assist Alfred. Or there could perhaps be some ability of an existing library book truck to assist him with some things, and then have a library staff member maybe do the things that another library staff do the things that Alfred cannot do. So she wants to work with him, but she's not so sure that spending a fair amount of money is actually going to be the answer. So the questions are that this has brought up are, could the director have asked Alfred about his health in the interview, about his capabilities, and how much leeway does the employer have with respect to accommodations if an accommodation has been specifically requested by an employee. So when we're talking about the ADA, right, the Americans with Disabilities Act, the ADA covers private employees with 15 or more employees, but it covers all state and local employees. And this is a little tricky because the fact that it covers, so Title I, the ADA is broken into multiple titles. Title I is the employment section of the ADA, right? So it's the area where it says, employers cannot discriminate against people with disabilities in hiring or in, the practice of work. Then Title II is specifically aimed at state and local governments, and it says that people with disabilities may not be prevented from, participating in and taking advantage of services and activities of state and local government. So things like public meetings, voting, and other government activities. That also includes employment. So for public libraries, it is parts 1 and 2 of the ADA that, are usually consulted when you're talking about an employment issue for a state and local government. Under the ADA, the employee must request the accommodation. I said must request disability. I meant to put accommodation in there. I apologize for that. But under the ADA, the employee, the burden is on the employee to request the accommodation. And the idea behind that is the employer should not be aware that the employee, does not have to be aware that the employee has a disability. So if an employee has a disability and is able to complete the requirements of that position without ever disclosing they have a disability, then great. And that is pretty much the aim of the law, that everybody should be treated the same, no matter what, conditions they may have. If the employee has a condition that affects their ability to complete one of the duties of their job, and they would still be able to complete the duty with accommodation, then it is up to the employee to request that accommodation. The only time that does not hold true is if an employee has an open and obvious disability. So someone in a wheelchair, someone with a visual disability who is using a device like a cane or a service animal, things that would, obviously would clue in the employer that this person has a disability. But where there is not an open and obvious disability, it is up to the employee to say, hey, I need an accommodation. So it was correct of Alfred to request the accommodation. The employer, however, can ultimately determine the appropriate accommodation. So, however, as long as the accommodation works, right? So the employer can't say, this is what we're going to do for you, and, propose something that just isn't really going to permit the employee to successfully, handle the job requirements. So the best way, to kind of handle this is this process where the employee and the employer work together. And so when you look at the ADA and you look at the titles and any kind of, the EEOC, the Department of Justice, they all have guidances for employers to successfully comply with the ADA. And almost all of these materials stress an interactive process. So even though the employer can have the ultimate decision on what's done, they have to have an interactive process with the employee to discuss what kind of accommodation would work best, what is the exact need, what does the employee feel would be best, and then work together to find a solution that is not only acceptable and doable by the employer, but is also going to make the employee successful. If they come up with more than one option, then the employer can decide between those options which one gets implemented, assuming all of them work. In many instances, if the employer doesn't care if all the options are comparably priced and have comparable impact on the employer's business, the employer might just say, we don't care which one. In that instance, the employee can make the determination. The employer is not required to provide accommodation if that accommodation would cause a significant alteration in services or an undue financial burden. Now, significant alteration in services would be something like if the employee needed the employer to could only come in during certain hours. So the employer would have to open earlier or close earlier, right? So that could be a significant alteration in services if another option could not be determined. But, significant alteration in services is not that, okay, now we have to do this, work process a bit differently. Or now, we have to configure this workstation differently. Like, significant alteration in services really rises to a particular bar and is not just what's inconvenient or what costs money. An undue financial burden is actually an incredibly high bar. So if having a municipality or a public library board or someone say, well, we didn't budget for this, or we're very tight on money this year, or this is going to mean that we won't be able to, put the addition, we're going to have to push off getting that new furniture for a year. Those are not considered undue financial burdens. The law rises the bar of an undue financial burden to a very, very large bar. Like we'd have to fire another person, or, we would have to close for a day a week in order to pay for, like there are different, the bars are pretty significant for undue financial burden. And again, that is something that you would discuss with your attorney. Again, I highly recommend that if you are not familiar with accommodations and you haven't really done them very often, or if you have an accommodation that is unusual and you've never faced it before, definitely contact your attorney, because this is something that you want to be careful of. Because if you do this wrong, it is very common and it could be very damaging, because it is very common to be sued, right? So it's very common for an employer to pay the price if this is not done with sincerity and in accordance with recommendations and the law. So also, in addition to the ADA, we have what's called the Persons with Disabilities Civil Rights Act, or PWDCRA. This is a Michigan law which mirrors the Americans with Disabilities Act, and it has some additional little twists. So it also applies to local governments. One of the things that it does is it does have the option of cost limitation, so it can limit accommodations by what they may cost. So it can provide employers with an option if that employer has 4 or less employees. So if you're a very small library and you have an employee requesting an accommodation that is going to be very, very expensive or very, very, complicated to implement, but particularly if it's going to cost the library a lot of money, then there are certain safeguards that this law puts into effect with regards to ceilings of cost that a library can be required to expend for accommodations. It also indicates that, failure to hire or recruit or promote a worker when just providing them with devices or aids like that book truck or that flatbed truck can be utilized to assist them and enable them to complete the job is illegal. So an employer in the hiring process, if an employee offers that they would need, anything from, a screen reader to a, something that, captioning, or, some other device or aid to help them do their job, and that they have the credentials and the experience and the capacity to do the job with that item, then the library could not refuse to hire them or refuse to promote them simply because of that, of they need that, piece of equipment. So that's something to know, and that's under the PWDCRA. So in sum, with the ADA question and with our friend Alfred, the library must consider Alfred's request as a formal request for accommodation. And hopefully they have a policy in place for how ADA accommodations work, because that is also something you definitely should have. They must also initiate a dialogue with Alfred and maybe have a meeting with Alfred to determine exactly what kind of accommodation, not just what he wants, but have a dialogue to really understand what is needed to permit him to perform the job they need him to perform. And so that's very important that they have that conversation. Now, the library they can, as part of their ADA policy, and a lot of lawyers would say they really should, require documentation from Alfred to verify that he has a disability. So a library or an employer doesn't have to take it on face value that an employee has a disability. They can require the employee to provide documentation that a disability exists, and a disability that rises to the level of a disability as defined by the ADA, which has a specific definition of what constitutes a disability. That documentation must be kept separate and apart from their personnel file because it is medical information. So that's something else that's very important. All discussions surrounding this process are private and must be kept private. So that means a supervisor cannot discuss this with other employees. So the only time, it's kind of like a need to know basis. The only time an employee would need to know about this would be if they directly work with if the accommodation directly affects them. And then they don't need to know why, right? They don't need to know why there's an accommodation. So that's very important. And as I said, the library may, again, make the final determination on which accommodation is going to be implemented, as long as the accommodation that they choose fits. So the library, again, should be careful when including physical requirements in job descriptions. This is very common right now, where job descriptions may say must be able to lift 50 pounds, must be able to, visual, they must be able to see, they must be able to hear. You want to be very careful with these lines in job descriptions. I would definitely, if you are putting that kind of language in your job descriptions now, not so much the weightlifting part as the must be able to see and hear and speak, which I've seen in a few job descriptions. You just want to be very careful about that, because that could be looked at as discouraging people with disabilities from applying. And it is well known that a person with a hearing disability or a sight disability or a speech disability has enormous capacity to can be just as qualified as anyone else to perform the majority of jobs with some accommodation. And that's the purpose of the ADA. So to phrase a job description that, oh, you're going to be a reference librarian, you must be able to hear, you must be able to see, you must, there has to, you want to be very careful of that. And so I would definitely consult your attorney if you're putting that kind of language in your job descriptions. You also want to make sure that your job description very clearly states that the library does offer accommodations and is an equal opportunity employer. So that's also something you want to make sure is listed, because that, again, can help shield the library from, accusations of discrimination, or even, in some cases, there are lots of activists out there right now that, look through these things and are looking for places to sue, just as to be an example. So again, those are things that you want to, kind of be careful of. Even though you put them in, you don't mean anything. You're not trying to dissuade people, but you want to make sure that you word that appropriately, and that you indicate that by all means this library would offer accommodations. You want to make sure that you permit the employee to choose the accommodation if that's acceptable, if that's not going to be completely detrimental to the employer. If the employer can afford to and is able to, best case scenario is that the employee choose the accommodation that they personally feel is going to work best for them. And that's, there's a lot of suggestions in ADA and discrimination law that this is a good thing. Down the road, if the employment situation doesn't work out for any number of reasons, the employee cannot necessarily come back and say, well, the employer did not provide me with adequate accommodations, because the employee themselves picked the accommodation. So there are pluses and minuses to everything, and again, if there is a question about this, or the library is in a situation where they're not sure, it's always good to talk to your lawyer. Make sure that you include Alfred as much as possible in the process. As I said, interactive discussions are crucial. Make sure that you have a clear and detailed policy for how accommodations work and how the accommodations, ADA accommodations process will go. Be very wary of declining an accommodation because of undue financial burden. As I said, that's an incredibly high bar, and you absolutely want to make sure that you talk to your attorney before you make that claim. You want to be knowledgeable about all of your options that apply to you as a small employer. For example, that Persons with Disabilities Civil Rights Act option of the financial ceiling of some accommodations is important and would be useful for you to know. The library must not use cost as the only factor in an accommodation, right? Courts don't care if a library's budget is tight. Okay, in almost every law that deals with discrimination or civil rights, the kind of the default is to accommodate the person who needs the accommodation or the person who is potentially discriminated against. So, you want to err on the side of providing accommodations. You want to not retaliate, discriminate, or discipline Alfred because he did not bring this up in a job description, in a job interview. The ADA prevents employers from asking about this topic in the interview process. So, once a job is offered, then the employer can get into a little bit more detail about things that, are required in the job. But even that, you have to be very careful with. So you can't just ask an employee, so you look a little old, is your back going to handle this? That is, even if you mean it in the most friendly way, don't do that. You want to make sure that, when you're interviewing someone, you don't mention, their health or their potential for, you can ask, can you do this job? Do you meet the qualifications for this job? And are you able to do these functions? And you can, go through them with them. Are you able to do this? This is what we expect. And if they say yes, okay. You can't pick at them and say, well, are you sure you're low your back, or you look a little chubby, or you're going to have a hard time climbing stairs. You don't want to go into any of that, no matter how well-meaning or friendly you perceive it. I have a resource sections at the end. I have a lot of links to a lot of very helpful guidances on the ADA. And on accommodations, so those also will be helpful. I also have quite a few on policies and quite a few on at will and the other topics that we've talked about so far that can also be very helpful. Our third scenario and our fourth scenario are somewhat related. So we're going to talk a little bit about COVID issues. So Everytown Public Library has a very diverse workforce in every sense of the word, right? So It is also very politically diverse, like much of our state is. The library does have policies in place for mitigation of COVID-19, and this is in accordance with state and local requirements and CDC guidance. It is consistent. These policies are consistent with recommendations and infection transmissibility and vaccination and illness rates within their community. Part of this policy requires that employees quarantine and remain away from the workplace if they are exposed to COVID or diagnosed with COVID-19. And exposure would be as the CDC defines it, which is within 6 feet of a person who is infected with, diagnosed with COVID-19 for 15 minutes total. And if they are not wearing a mask. If they are wearing a mask, they do not have to quarantine, but they do have to get tested, and that's the CDC current guidance. So there are a few unvaccinated employees in the library that have experienced multiple exposures. Okay, so they're unvaccinated, they do not believe in vaccines, so it's they keep getting exposed. Okay, they keep putting themselves in situations, or for whatever reason, their kid comes home from school, whatever the reason is, they consistently are exposed and they consistently have to quarantine. So they're out of the office for 10 to 14 days at a time, and this has happened repeatedly. The company does have a pretty expansive leave policy, which permits employees to use their personal leave, vacation or sick days, so they can get paid, or they can work from home if their job is able to be done remotely. So this library does not have a huge staff, and these two employees work in public services, and they tend to work hours that are evenings and weekends. And what's happening is this staff, the fact that this staff is constantly not in the office means that schedules have to be redone, and some work and programming either has to be canceled or other employees have to cover. So what's happening is the vaccinated staff are getting very frustrated and exhausted and overworked to cover for the unvaccinated staff that have been repeatedly quarantining. So as part of this, a group of staff approached the director and complained about this situation. They were mad because they feel that these unvaccinated staff members are inviting infection and acting irresponsibly. The staff said that the social media accounts of these two, the publicly available social media accounts of these two staff members display postings that are consistent with anti-vax and COVID misinformation. They also have feature pictures of employees in restaurants and at events without masks. Both employees have also posted various opinions, including a statement saying essentially that, at my job, my job is completely brainwashed by the COVID-19 sham, but I get to work from home every time I am exposed, which is great. So the joke is on them. So understandably, this is creating some conflict in the workplace. The vaccinated staff make a formal complaint that employees are taking advantage of the policies and benefiting from their irresponsible behavior outside of the workplace that is affecting the library's operations. The director is inclined to agree. So the question here is, what are the options? So this actually is a question of off-work behavior and speech. Because the library may have a policy about wearing masks and about having, and about quarantining, and the employees are following the quarantining policies. So they're following what they're supposed to be doing in certain situations, but they're arguably put in those situations because of their personal behavior. Now, the laws we're talking about here would be the First Amendment under the United States Constitution, which applies here because the library is a government entity. If we were a private employer, it may not. The COVID-19 Employment Rights Act, which is a Michigan law, and any municipal ethics ordinances that may exist. And some municipalities have ethics ordinances, and this would be in the municipal library, that, specify kind of expected behavior or actions from officers or employees. So depending on whether or not your municipality has one and whether or not it applies to employees, could impact some of this. Because if there's a municipal ordinance, that's a ethics ordinance that says, municipal employees are expected to, behave responsibly and to support their, adequately maintain and respect the assets of the government and the taxpayer money, like something like that could possibly be looked at as these employees may not be doing that because they're negatively affecting the library through their actions. But again, that is a very gray area. So those are the laws we're talking about. So the ability of an employer to discipline employee for actions or speech that occurs outside of work. I see, I put the instead of that. Public employees are protected by the First Amendment. Political speech is particularly protected, which could be the situation here on these employees' social media platforms. However, an employer can address actions or speech of employees, even outside of work, that reveal trade secrets, that violate other laws, right? So that if, for example, if the employees were putting out lists of patrons and what they read, right? That constitute harassment or discrimination of other employees or patrons. So if the employees are posting on their personal message boards hate speech or language that is meant to intimidate or insult fellow employees or patrons. In other words, their statements could be part of creating a hostile work environment. If the statements are libelous, so in other words, if they're posting lies, they're posting things that just aren't true and are making people look bad. If the things that they post have a negative effect on the business. So if by posting this, they are trying to convince people not to go to the library or to instigate a boycott of the library, or better yet, to not pass a millage. Not passing a millage would be a pretty clear example of a negative effect. Or they're harming the reputation of the business. So they're saying things like, the library is, indoctrinating people only on their liberal agenda, and the library is, hates their employees. And, if they're saying things that could harm the reputation of the library, and again, the ability of the library to do things like get grants, recruit good employees, get their millage, things like that. However, this is a really, really gray area, okay, because of the First Amendment implications here. And especially when you're talking about, which this does kind of reach into. the action the library takes has to be very carefully considered. So they need to look at, are there other laws or regulations that could affect this? So there could be MIOSHA involved. There could be the COVID Employment Civil Rights Act, right? And the COVID Employment Civil Rights Act, we're going to get to in just a minute. MIOSHA, a lot of you should probably be aware by now that that is the health and safety, the Worker Health and Safety Act in Michigan. The general duty standard says that employers must do what they can to prevent their workers from encountering hazards in the workplace. And so there could be an opening there for employers to address employees' personal behavior and how it is negatively affecting the workplace in terms of possibly transmitting COVID to the workplace, and possibly, but on the other hand, MIOSHA would also require it doesn't outright require. In other words, there's no particular MIOSHA standard that says you have to quarantine, but quarantining employees who have been exposed is keeping workers safe from workplace hazards. So the libraries, by having that policy, is doing what it can to keep its workers safe. Does the library have a social media policy or a policy that discusses on or off work behavior? So social media policy, they're kind of in the last year or so becoming popular. So the social media policy pretty much would tell employees, we expect you to not post trade secrets, not negatively, not disparage the employer to the extent that it negatively affects our business. Lay out those things that the employer is able to address. It can't come out and say, don't talk about us, but it can say, this is, if you post things that are interpreted as harassing fellow employees or are hate speech, or that negatively affect our reputation, then we will do this, is the kind of policy that can say. And I do have a link to some samples in the and information on those in the resources. Were any laws violated by the employee, right? So is the employee on social media relaying an incident that happened where they broke the law? And this could be something they did outside of work, right? So does it show them taking illegal substances? Does it show them engaging in behavior that is, that's illegal? And that, that right away, if they're showing pictures that clearly show that they committed an illegal act, that could negatively impact the organization and they could be fired. And this is kind of what you've seen with the fallout of some very well-known social media issues, and with the January 6th controversy, where employees who were at the Capitol in Washington, possibly committing some illegal activities, when their social media reflected that, many of them were fired by their employers. And that's the basis the employer used, is that they were committing some illegal activity, and that illegal activity can affect the employer's reputation. As well as a lot of employers have employment policies that say, if you commit a felony or you break the law, your job could be in jeopardy. So what effect do or could the actions have on the library? And again, that kind of speaks to this idea of negative reputation, or effect on the business. Could the library be negatively affected by any options for action in response to the employee's behavior? So if the library were to fire these employees, could that action create a bigger negative effect than the negative effect that could be had by, you know, letting their activity go on. So again, these are some things that you would want to talk to your lawyer about, right? Because there could be many ripples, right? Maybe the library could face a lot of backlash in the community for taking this action. But if they didn't take the action, maybe they would risk a walkout or other negative employee activity by the employees who are protesting this. So there's multiple sides here that a library would want to perhaps discuss with their attorney. And lastly, like I said, what would be the effects of not dealing with the issue? So then we have MIOSHA General Duty Clause. And the duty clause says, as I said, that they must provide a workplace free from recognized hazard. So COVID-19 is a recognized hazard. Employers must implement appropriate protocols, even if there are no mandates or requirements, because that hazard exists. So not having a policy, a masking policy, or not having mitigation measures in place is not going to solve this problem. It could create bigger problems. And if you have a COVID outbreak at the library, and it can be traced to the likelihood that because measures were not in place, then that could create more trouble for the library. So, just not having or, watering down your policies is also not necessarily the answer. The COVID-19 Employment Rights Act requires employees to prohibit employees that are exposed or that have COVID from entering the workplace. Now, it says in accordance with CDC guidance. So, for example, if you have an employee that's vaccinated and wearing a mask and they were exposed, then the CDC guidance would say they do not even have to quarantine. They just have to get tested. If you have an unvaccinated employee who was exposed under CDC, again, within 6 feet for a total of 15 minutes, they do have to quarantine for between 10 and 14 days, depending on circumstances. However, quarantining does not require paid leave. There is no law that says that an employer has to offer paid leave. If you have family medical leave would be implicated, but employers can require that an employee exhaust paid leave before taking family medical leave, or exhaust, in some circumstances, they can exhaust paid leave in conjunction with family medical leave. So these are things, again, that you would want to discuss with your attorney to see if these would, are policies that are, right for your facility. It does not require a work from home solution. There are no requirements for work from home. But it does prohibit an employer from disciplining, retaliating, or discriminating against an employee for quarantining or isolating. So in this circumstance, it would be very difficult for the library to discipline or take action against these employees for quarantining. And if, for example, they could show that pictures on social media that show these employees out and about occurred during the time they were to be quarantined, that would give the library an opening for action, because it's, there are some violations there. But if the employee is just been quarantining, multiple times, there's really nothing the library can do for that instance. They can talk to the employee and explain why this is a problem, but it gets really kind of complicated and gray. So in this instance, this is really an instance where this employer would really want to have a good conversation with their employment attorney. They would want to gather all the information that they have, and they would really need to have a good discussion with their employment attorney before they took any action. because they could do things like revoke the work from home policy. They could change their leave policies. But if the changing of the leave policies can be connected to these two employees, then there may be an argument that they are retaliating against these employees for leave, taking successive quarantine, and that's a violation of that law. So again, this is a situation that just has so many different sides and grayness that it's really worth a discussion with your attorney. I would not handle this situation on your own. Okay, in sum, the library has to comply with the COVID Employment Civil Rights Act. They have to comply with MIOSHA, especially the general duty standard, and they really must respect the employee's First Amendment rights. The library should consult their employment attorney. They should look into implementing a comprehensive, clear social media and employment behavior policy. They should provide employees with ample, credible information on COVID-19 and the vaccination, and not just once. They should repeatedly provide information to those employees and make it easy for the employee to get vaccinated, right? So remove bars for the employee to get vaccinated. Keep their leave and remote work policies updated and flexible so that they can address situations as they come up, but be wary of changing them in response to a particular situation. The library can talk to the employee, as I mentioned, to see what the issue is and to see if, let them know that their behavior is not only known, but what the optics are, how this looks, and that this is causing the library some problems. They can, as I said, modify or amend, but they want to be careful about that. Or they could come up with a different solution to resolve the issue in an out-of-the-box manner. Things like, if you have this kind of situation, there's really not a lot you can do for the employees that are creating the situation. So the situation is not getting any better. You still have employees that are continuously quarantining, and you still have vaccinated employees that are very stressed. Maybe the answer is to reduce services. When the library is very short-staffed, you go to curbside, or you reduce your hours so that your vaccinated staff are not overtaxed. Because it's important, to remember that staff that are there, that are working harder and having to deal, with more than they normally have to deal with, they get tired and they get stressed out and they get burnt out. So you don't want to lose good employees for things like that. That sometimes the best option is just to lower your hours and or go to curbside so that you're kind of, taking it easier or giving your other staff a break. Make sure you communicate with staff. What libraries should not publicly shame staff, tolerate harassment of staff by other staff, and that's on either side of the political aisle, right? So you can't have vaccinated staff bullying unvaccinated, and you can't have unvaccinated staff or staff that are, resistant to masks bullying staff that are wearing masks or that are vaccinated. You can't just change policies on leave, that in response to things that employees who are quarantining are doing. And like I said, I wouldn't change policies on a staff member while they are on leave or remote work. You want to be careful about suppressing political speech. You do not want to discuss the behavior of employees with other employees. So having a gripe session with staff is not a good idea. And again, dismiss, discipline, or retaliate against the employee for quarantining or for being exposed to COVID-19. So we're about at the end of our time, and I want to address this last question, which really rides on the back of the one we just did. So I'm quickly going to mention it. This question has to do with, again, it's a COVID issue, and it has to do with an employee who refuses to follow protocol. I have been getting a lot of questions about both of these last two scenarios. So this is actually really happening. If you have an employee, you have a mask requirement, and you have an employee who refuses to mask, Once you ascertain that the employee does not fit within an exemption, does not have a medical condition that would prevent them from wearing a mask, or does not have a religious objection, then that boils down to a violation of policy, right? So your protocols for when an employee violates policy could kick into effect. One of the things you have to ask yourself is, how far am I willing to let this go? And am I willing to fire this employee because they are not adhering to policy? And that is a question that only the employer can answer. It may be yes, because it is creating enough upheaval in the workplace that it is worth it. Other options are, can I change the employee's schedule, job duties, location, to mitigate the risk with other employees? Remember that there is still a myosha element here, right? So if you have staff all wearing masks and you have one staff not wearing a mask, particularly if that staff is unvaccinated, then you're kind of going into a workplace hazard issue. And you have to consider if there are other things that the library can implement to maintain the safety of the workplace, and permit this employee to circumvent the rule. And if you can, how many employees are you going to permit to circumvent the rule? Because remember, you can't just do it for one employee. So this is really a situation of, a good employee who refuses to follow. And refusal to follow policy is really, a common law issue, which means it's set by case law, right? That's how states get their laws and requirements, and the ability to say, an employer can do this. So as long as your policies are legal, enforceable, fairly applied, and as long as you have a policy that says employees must follow employers' policies or face the consequences, then the employer can initiate a disciplinary process. And if you have a staff member that is really valuable, then you may want to enter into a conversation with that staff member and have a really clear heart-to-heart with that staff member and let them know that continued disregard could severely affect their employment. And unfortunately, that's a complicated conversation you may just have to have. And lastly, there are something else you may want to consider during these COVID times is having your staff be required to take conflict management classes. The Niche Academy here at Library of Michigan through our Continuing Ed, as well as Web Junction through Continuing Ed, our Continuing Ed website, each have web-based courses, and they're self-guided, and they can be done at any time, and they're free, that can teach some of these conflict mitigation skills. And if you are having a lot of conflict in the workplace between employees over really any issue, but particularly over these issues with COVID, you can have a policy that says, employees have to peer mediate issues first before coming to management with problems relating to, following procedure or, disagreements in politics or disagreements in how things are done, and give them the tools to learn how to mediate, do that, and require them to do this training, and it can be that can be very helpful. And talk to your attorney about any other possible policies that may help your situation. In a lot of instances, having some frank conversations with staff can be helpful about, what do they object to, why do they object to it, and providing good quality information can sometimes be helpful. Although at the end of the day, there are circumstances when a particular employee is just going to have to be terminated for not following procedure. It's also, you can tell the employee to investigate if they're fired, whether or not they would get unemployment. Because there is a rule in Michigan, there's one of the regulations for unemployment says that if termination was for, what's the word? Like rampant violation or intentional violation or like insubordinate violation of policy, it's possible they won't get unemployment. So, that's something to be discussed with the employer that the employee may not know. So in the information you're putting out, about your policy and about, your COVID protocols, that may be information you want to put out there too, that there may be a problem getting unemployment if you are willfully violating policies of the employer and you're fired for that. So I want to say thank you for sticking with me. Thank you for I appreciate everybody. I know I went a few minutes over. I will be providing copies of the slides to Becky, along with the many pages of resources at the end of these slides that also include some sample policies and links to some classes that on conflict management that could be helpful. So I hope that this has been helpful to you. And like I said, there's just a lot to discuss here. I've gotten a lot of employment questions recently, particularly with COVID. I know a lot of people are having a tough time out there, and that just really stinks. And I feel bad for all of you. It's been kind of a tough road the last couple of years. Please don't hesitate to give me a shout out if I can offer you any assistance or any additional information. Please find a good employment attorney if you are having problems. And I would recommend you find one anyway that you can reach out to when you need them. And thanks a lot. I appreciate your time, and I hope you all have a wonderful weekend.